Well, welcome everyone. Yep, we're recording now. I'm so glad everybody is here for this webinar. A couple of quick notes. The reason that we're having this particular webinar is because of the work of our Workforce Development Committee, who here a few months ago, we had a meeting, our annual roundtable, and the subject or the topic of performance management came up as an educational opportunity for our members. And okay, let me admit, I don't want to leave anybody out. Bear with me. Okay, I'm trying to let people in the door. So the Workforce Development Committee met and we were talking about things that we'd like to help our members with. And this subject came up, performance management. And we talked about it and we said, well, let's explore and maybe do some webinars. So I thought about my good friend, Bert Brannen, and I met Bert about nearly 25 years ago. Bert was my first labor lawyer at Fulton Concrete. So we've had a long-standing friendship, and as we got to know each other professionally, we learned that we grew up in adjoining communities in Atlanta and had some common friends, and we overlapped at Georgia Tech a little bit, and so I've got a lot of experience with Bert. Bert brings over 40 years of employment law experience, and rather than me try to recite all of that for you, I'm gonna hand it over to Bert and let him introduce himself. And I think I'm excited about this, and I think we're going to make a little mini series out of that, but we'll talk about that a little bit later. So Bert, thank you for being with us and sharing your knowledge.
Well, thanks to Bill and Emily. I'm excited to be here. You know, most of my life is crisis driven, but this is more educational, where I can translate the crises that we deal with into some forward-looking education. Today, I want to talk about employee engagement with accountability. Now, that's like a political euphemism. To give you sort of the background, you know, I've done this for 40 years, and the number one topic that people have always asked for is discipline and discharge. And to me, that's just so negative. Then I morphed it into its performance management. My modern iteration is its employee engagement. So let me kind of give you some insight into that. As a labor lawyer for 40 years, I've literally done a lot of work over the decades in the aggregate, cement, and ready-mix industries. I broke my teeth for the first decade on Ideal Basic Industries that became Whole-Nam and Whole-Sim, and had union drives with Williams Brothers and Blue Circle, if you can remember those companies. And, you know, fast forward, I represent Wayne Davis, and I've always represented some kinds of companies in your industry. And we want to educate you, and we do these seminars to do that. And people are always going, I want to learn about how to fire people. And I'm like, but that's so negative and destructive. And I've tried to morph this presentation over the years, but it's essentially the same thing. Bill and I were talking this morning, you know, everybody uses the word culture. I like to gravitate to engagement. Culture is like an environment. It's like the atmosphere. To me, employee engagement is having employees actively involved in your business and engaged in a way that they give you 100%. And that's the culture we want to create. My goal today is I want to inspire you to help all the people in your organization understand how all the administrivia of human resources really does fit into creating the right culture of employee engagement. And to me, it's perspective. It's when you realize why you have to have 3 people interview someone, or why we have to write them up. You know, it's because we're trying to get the best performance out of people. Discharge is the last resort. we're not trying to set people up to fire them. We're trying to set them up for success. So if you think about what I've done over my career, a lot of it is, how do you stay union free? Or how do you create a safe work environment? Or how do you avoid claims of harassment, discrimination, retaliation? The common denominator in all those things is, if you have engaged employees, they won't cause those kind of problems for you. So I want you to have that perspective, that overview, that performance management or discipline and discharge, those are the transactional things. But the whole idea is to have the best environment for people where they feel fully appreciated. They want to contribute all their skills, talents, and energy for the success of your business. Now, the fact of the matter is that most human resources transactions have some connection to performance and ultimately engagement. Again, I want to inspire you, the people on the phone, and help you inspire those that work with you that are often resistant to these transactions, that it really does fit into our overall holistic approach. And again, the idea is to set employees up to succeed and not fail. The goals of management and HR are to serve the company's interests. You are supposed to be aligned. You're supposed to establish processes that help you, management and HR, get the employees' very best talents, efforts, and results. And if you have this engaged group of employees, then they're going to perform well and have standards of excellence. So this might be sort of Covey-esque, but if you think about all of the management and HR processes from start to finish, we can put them into 4 categories. And it's very simple. This is, Bill was saying, now we've sometimes skipped the basics or the foundations, but this is the progression of an employee, or of how HR primarily manages employees. We get the right people, we set clear expectations, we coach people up, and then, frankly, we get rid of the poor performers. And if you skip any of these steps, then you're not going to get the best out of your employees. You're going to have legal problems. You are going to end up with unsafe workplaces or discrimination, harassment. But this is the overall process that relates to performance management. So it starts with getting the right people. I used to live in Vinings, and there was a swimming tennis club down there. And next to it, there was a big field where all the kids would play soccer, typically on the weekend. So I coached one of my children with a guy named Ben Haverty. And so every Saturday or Sunday, we would go out to the soccer field and we would check out the good soccer players. And then we'd talk to their moms, typically around the pool, and go, Robbie, he really needs to be on the Barracudas. We've got a great soccer team. And fast forward to the season, we'd be up 8-0 in the soccer game. And Ben would look to me and he'd go, yep, better coaching through recruiting. We look brilliant, but we had the foreign team, the Cochise Club there in Vinings. But the point is, if you get the right people, you have a whole lot better chance of succeeding. Now, it really irks me to have Gunnar Stockton here, but you think about it in football. Nick Saban, Kirby, they always get the best players. And guess what? They look like brilliant coaches. So getting the right people starts before you hire them. That is recruiting them, where you recruit from them, how you screen them, actively interviewing them, the hiring process. And the point I want to make here is, even that first 90 days is still part of the screening process. And a lot of people have what I call the fog a mirror approach. If you can fog a mirror, we're going to hire you, we're going to put you in a truck, and you're on the road in 12 hours. That's really not setting them up for success. And if you don't continue to coach them during that 90-day period, you lose some opportunities. And, really the introductory period has lost all of its legal meaning, but it is a great way to set expectations so that you go to somebody after 45 days and go, it's not working out. Remember, we told you you're in an introductory period and you're not meeting our expectations, so you're not going to be here anymore. But the point here is using that introductory period is an incremental part of getting the right people. And so don't forget about that. And you have to get your management team on board. It takes time to do proper background screening. It takes time to do interviewing and go through the hiring process. And yes, there's a legal component to it, but if you short circuit or skip parts of this, you're going to end up with the wrong people. Ultimately, you're going to terminate them, and that's really when most of the legal risk starts. But part of this is convincing your stakeholders inside to slow down, be patient. Let's do the time, spend the time here. Anecdotally, I heard a long time ago that 80% of all the matters that labor and employment lawyers deal with come after employment ends. Now, that might be a wage and hour claim, an OSHA claim, sex harassment, or a wrongful termination. But the vast majority of claims that the lawyers deal with occur at the end of this process. What's important, less than 2% of the cases come because you don't hire someone. So my advice is, if you don't like somebody 100%, don't make them an offer, because the odds that you're going to get sued on the front end are significantly lower than on the back end. And so I can't encourage you enough that that's a worthwhile use of your time and of your management stakeholders. So when they, I don't need to sit in an interview, or we don't need to do this paperwork. Yes, we do, because we're setting ourselves up to succeed. So another missed opportunity is properly setting expectations when you onboard people. You get the right people who come in with the right skill set, the right experience, the right attitude, and you give them a thorough onboarding or orientation. And you do this all sorts of ways. We have, employee handbooks and other training when they first come on board. But that process doesn't stop once someone is through their orientation. Throughout their career, employers are setting expectations for employees. Now, you can do that through memos, through periodic reminders or training sessions. You can issue your no harassment policy and go, from time to time, we like to reaffirm our commitment to maintaining a workplace free of harassment, discrimination, and retaliation. Please see our attached policy as a reminder. Or you may do that about your drug testing policy. But from time to time, you are setting the expectations. And, I'm reluctant to compare employees to children, but there are many similarities. The more articulate you are about setting the boundaries or the rails, the less likely they are to go outside of them. We all know that employees can do some silly things, whether it's on social media or in the break room. But if you tell them, don't spit in the coffee pot, they're less likely to do that. So training and these memos, you constantly set expectations. So let me just take a minute and step back from all these legal-based policies. I'm sure everybody out there has a no harassment and an EEO policy. You've got electronic communication, social media, blogging, workplace policy. And all the managers probably think, oh yeah, the law requires that. But I want you to think up on the balcony, as they say in negotiations, if you're a person of color and you're feeling discriminated in the workplace against, or if you're a woman and you're constantly being hit on, you're not going to want to come to work. You're going to have a higher rate of absenteeism. You're more likely to be tardy. You are not going to put your chin out and be totally engaged in the business. So if you have a culture where people are harassed or subjected to bullying or violence, we're not going to get the best out of people. So we need to convince the management team that these aren't just legally required policies. They're good business. We want to create an environment where people feel protected and empowered and not subject to harassment, discrimination, much less workplace violence. So a lot of our policies where we set expectations, they really do transcend just the legal. The goal of having these policies is to set boundaries and create an environment where employees feel empowered and engaged. Now, part of the expectation setting process, remember we're in step 2, is a culture of compliance. Whether it's, people call it now culture, but we all have ethics and standards of profession. We want our employees to abide by those things. How we treat people, making safety a priority, understanding that our policies, and we have these for a reason, and we expect you to comply. And obviously, we want you to comply with all applicable legal requirements. Now, management has a very significant role to support HR and part of our expectation is that you are going to document things. Again, that's not for the lawyers. Documentation is the very best way to communicate. So when you tell someone, I expect you to do X, Y, and Z, and if you don't, your job is at risk, it lands, it resonates in a way that doesn't when you just talk to them. So a culture of documentation, and I'm not talking about being little traffic cops or, parking police, but the level of documentation that's necessary to communicate effectively is part of our expectations. And obviously, being a labor and employment lawyer, I want you to have a culture of compliance with all our employment laws. We want to keep workers safe. If you keep them safe, by the way, you take away the number one wedge issue where unions can come in and solicit employees. Because after all, if you tolerate employees working in an unsafe environment, then the message to them is you don't really care about them. The same thing's true with not solving their problems. But we do expect all of our people to comply with the no discrimination and no harassment laws, again, for good reasons, not just because it's required. We want them to know that we'll make reasonable accommodations for qualified individuals with disabilities. We want people to know that we give protected leaves and we're compliant with all the wage hour laws, and that we're not going to retaliate against whistleblowers or people that express concerns or complaints. But that's part of the setting expectations phase here. So before we leave that, I want to give you this pyramid that I've developed. A lot of people get stuck in the transactional basis of what we're talking about. They think mere legal compliance is enough. That's not true. We want you to comply with all of our company policies, and we want you to go above and beyond that so that the culture, the environment where employees work is engaged to the maximum so that they perform to your high and ever increasing standards. So just think about that. We're not just talking about documentation and policies. We're talking about using those as tools to create a culture of engagement. So again, if we just refresh, you get the right people, you constantly set expectations, you tell them where the rails are, and then you coach them up. And there are a variety of different ways to coach people. Basically, it's discipline and discharge. But that's so negative. So part of the coaching is, well, what are our key performance indicators? How do you measure success? Communicate that, have that. A lot of you probably post your metrics on the employee bulletin boards, whether it's waste, yards delivered, whatever. But it's helpful to give employees metrics of their performance. We can use performance evaluations, which are positive, and discipline, which is negative. Sometimes you have a a seasoned trainer work with someone that's new or not performing, and that helps you coach up their performance. Now, in a few cases, you might hire a coach or even go through a sophisticated 360-degree process. But basically, the way you coach up people is through discipline and performance evaluations. So let's talk about those two primary ways of coaching up performance. When someone knows that they're going to be disciplined, I think of a turtle, and they come into your office and they put their head in their shell the minute you start indicating it's a disciplinary counseling. And half the time, I don't think they hear a word you say after, "We're going to have to write you up." They become defensive and uncommunicative. It's a very negative experience, not only for the employee, but for the manager having to deal with that discipline. But when you give performance evaluations, that's a more positive, more likely to be constructive, because many people meet or exceed expectations. So the manager feels better about it, and the employee feels better about it. It's a much more open and communicative dialogue there. But those are really the two primary ways that we coach people up. You know, the Pareto principle, the 80-20 rule. So think about it. You spend 80% of your time working on the 20% who are non-compliant. That's one way to look at this principle. Another is, if you spend all your time working on the 20% or hopefully less who are not meeting expectations, how do you coach up the other 80%? If discipline is your only means of improving performance and you only discipline that 20%, how do you raise the bar and get improved performance from the other 80%? I would submit that without evaluations, you can't pay attention to the more important 80% who are more likely to stay, by the way, and not on the track to be terminated. So there's been a lot of talk in the research and the literature about, performance evaluations are a waste of time. I disagree. Now, if you read deeply into the research, it's really that you should give regular, almost daily feedback, not just once a year. So a lot of people misconstrue, I think, what the academics say about you don't need to do performance evaluations. So just to be clear, I'm an absolute fan of regular performance evaluations because they are the way that you coach up and help the good performers to get better. And if you want to create a culture of continuing search of excellence, constant learning, and you don't have that opportunity periodically, you're not going to improve the largest number of your employees. So I would say get people to buy into the evaluation process with this, what if we didn't have it? Again, I promised I wasn't going to talk politics, but when the U.S. decided to bomb, was it Operation Midnight Hammer, I heard that the security advisors were meeting with the president, and after getting briefed, his insightful question was, what if we don't do that? It wasn't, how are we going to do it? It's like, well, what if we don't? Well, they're going to get a nuclear weapon. Well, that made the answer obvious. So hopefully, my question to you is, what if you don't do regular evaluations? Then you're not going to coach up the 80%. They're going to slump to mediocrity. They're not going to have the standard of excellence that you want, and you're going to miss a real opportunity to improve performance and create an engaged workforce. Now, the problems with evaluations is, managers aren't buying into the process for all the reasons I tried to explain. There are differences between evaluators. In fact, I did a full quarter research project when I was at Georgia Tech on inter-rater inconsistency at the Student Career Center. And I proved statistically there's a incredible difference in how raters rate people. And so think about it, Georgia Tech, you had companies like Exxon and Chevron and, very big companies coming in. And so the only thing they had to do to have access to the Georgia Tech students was they had to fill out like a 10-question evaluation where they ranked them 1 to 5. And so I took 300 students who had been rated by different evaluators, more than 10, if I recall, and proved statistically there was absolutely no correlation from the Exxon interviewer and the mobile interviewer. One guy would give him a 5 and one a 1. My point is, you can expect that your managers will rate people differently. And so you've got, as HR and management, you've got to sort of set the standards and rein that in. Not doing them on time, not doing them consistently, those are other problems. The lack of objectivity is a real problem. And there's a thing called the halo concept where you rate someone year after year because of one incident that occurred a long time ago. They never outgrow that halo because of something bad. So coaching them up on how to do them objectively is a very important part of the process. But again, I would submit that evaluations are the way that you get to coach up performance in a constructive, more positive environment than discipline. And if discipline is your only means of coaching people up, you're sort of missing the boat. After the evaluation, obviously, the results should be confidential, except among those who have a need to know, like the management team and HR. But you don't go sharing evaluations with peers. The evaluation process is not a one and done. The feedback should continue throughout the year through other forms of coaching. Again, we have a right to demand high expectations. We have a right to meet with them and coach them up and give constructive feedback. And it shouldn't stop once a year. It should go on every time something good happens or something bad. And typically, it should be immediate. Think about it. If you get feedback after 9 months, you can't really adapt your behavior. But if you get feedback the next day about, a dispatcher customer interaction, the dispatcher is going to learn quicker than if you stockpile all the errors and talk about it at the end of the year. The supervisors need to make notes throughout the year for the next evaluation so they can use objective indicators of good or bad performance. And for those people that you rate as not meeting expectations, you can follow up on those. Don't just avoid talking to them for the next year. So again, we're at the coaching them up phase, right? So we have evaluations, and then you have discipline, which has much more negative connotations. But there are some guiding principles about discipline that we all need to know about. It needs to be timely. It needs to be consistent. And that's not necessarily for legal reasons, but employees lose respect for management when you're inconsistent. When you discipline someone for some behavior and employees see that, that's a way of putting them on notice. So consistency is a way of reinforcing probably a written standard somewhere. But that consistency sets the parameters. It appears fair. Employees go to unions because managers are arbitrary. They have favorites, and they're not consistent. It needs to be as objective as possible as opposed to subjective or qualitative. You're not good enough. Well, your KPIs are objective. Your actions or your words, they're objective. You need to be as impartial as you can. In a perfect world, we want discipline to be progressive, verbal, written, suspension, termination. But for years, we've cautioned you, don't put that in writing. You can talk about all the ways you might be disciplined, a bucket list of work rules. You can refer to the typical process, but you shouldn't commit an employee handbook to an absolute, rigid step-by-step approach because every situation is going to be different. And then lastly, discipline, like a military response, needs to be appropriate. You don't use a nuclear warhead when a rifle will do. So when a written warning will do, you don't terminate someone. But those are some guiding principles that I've lived by in terms of discipline. Before we leave it, just think about it. Every kind of disciplinary action literally can be put into two buckets. Either it's misconduct or it's poor performance. Now, as your lawyer, I'd much prefer to defend a misconduct case. You have a work rule. It is much more objective. It's defensible. It's based on specific actions. So to the extent you can, even if you have a mentality of trying to avoid every unemployment claim, pigeonhole people into misconduct, and you're much more likely to win unemployment claims and downstream lawsuits. Plus, the employees are going to think it's fairer and more consistent and not arbitrary. Performance is a lot more difficult to deal with because typically it's more qualitative, it's subjective. The standard for poor performance is typically the poorest performer out there. It's not some work rule or KPI. And so the standards are a little squishier on performance, which means it's a little bit harder for us to defend, and certainly for unemployment, which shouldn't be your total driving force. But for unemployment, you're less likely to prevail on a performance discharge. So a long time ago, I learned this acrostic for performance discipline called NEAT, that you give the employee notice that they're not meeting your expectation. You explain to them what's wrong. You try to find some way to help them, whether it's a work with, training, a new course, anything like that. And ultimately, you give them time to try to improve. And if you do those things, employees might be rehabilitated, but if you end up terminating them, it'll be much more defensible. Because whether it's unemployment or a court, they're going to say, did the employee have noticed that their performance was not meeting expectations? Yes, here's their performance evaluation. Here's discipline. This is what we've done for other people. They were clearly on notice. We sat with them and said, you need to do X, Y, and Z. It was documented. And then we gave them some help, which means we weren't gunning for them in retaliation or to be punitive. We genuinely wanted to rehabilitate the person. We gave them a special computer program or training or a work with, and ultimately we gave them time. And when they didn't improve, we had no option but to terminate their employment. Now, the longer someone has been with you, the greater their expectation that they will stay there. And so when you don't tell someone for a decade they're not meeting your performance expectations and they just linger on as a mediocre employee, then you're going to have to simply give them more notice and more time and some window dressing assistance before you just throw them out of the organization. If you're going to write down anything today, I'd say this is it. When you issue written discipline, it should always end with this tagline. And I know the slide's got a lot of words, but let's break it down. Think about it. You're disciplining someone, and so they've engaged in some kind of conduct. So it starts with, if you repeat this conduct, whether it's tardiness, absenteeism, insubordination, whatever, if you repeat this, and think about the two buckets we just talked about, or you fail to follow our rules of conduct, or to meet our standards of performance. So think about it. If you repeat this or you do anything else, then there's going to be further disciplinary action up to and including termination of your employment. So the first three phrases of that capture anything they could possibly do. I bet everybody on the phone here has warned somebody they're on final warning for poor attendance, and then they might, get into an altercation with a customer. And then you go, but wait a minute, they were on final warning for attendance. And a lot of people go, well, I can't act on this other. Sure you can, if you have this kind of closing statement. Now, the one last point here, I've seen, 90% of lawyers will tell you the first part of this. I want you to focus on the word immediate termination. That's a key word that most HR people and lawyers do not include in this closing tagline. But that's really what sets them up. So when they do something that you think warrants immediate termination, you can point to this document and go, we warned them that they could be subject to immediate termination. So the goal, again, of discipline and performance evaluation is rehabilitation. I think organizationally, our last resort is termination, right? So here in this fourth phase, you have to set up a termination properly. And again, it starts with getting the right people, having documented expectation setting, having discipline and evaluations. And if they don't rehabilitate themselves, then you're going to be perfectly okay terminating them. You might consider some kind of outplacement as a performance management tool. But getting here, you have to have some kind of documentation. And again, I'm not by any stretch purporting to be the parking ticket police, but certain basic documentation is going to be critical. And remember that 80% of the claims that we deal with follow the end of employment. So if you follow this four-step process and ultimately you have no choice but to terminate someone, then it's going to be much more defensible. Another very significant point to remember, though, is your credibility is your most important asset when you get challenged. So we don't want you lying or pussyfooting around or sugarcoating things. Tell the truth. If you suspect someone of theft or some other violation, that's okay. They're an at-will employee. But don't say we're going to lay you off and then hire two more people in the same role, or worse yet, advertise publicly for people to replace that person. This St. Mary's case involved, it was out of Tennessee, it was a hospital, and they thought this woman was stealing from them. They did a very detailed forensic accounting search, and they were basically able to prove that she was stealing. So they called her in and they said, we're going to have a reduction in force in your department. Well, she was suspicious. They never mentioned the theft issue. And so she sued them. And there's a motion for summary judgment where if there aren't any disputed facts, the court can rule on the paper and go, one party wins, the moving party wins. But if there's a conflict of material facts, the court can't dismiss an employment claim. A jury has to make a factual determination, not the court, not the judge. And so the employer moved for summary judgment saying we clearly proved that she was stealing from us. And the other side said, but wait a minute, you told her it was a reduction in force. And so the point here is they lied or sugarcoated it, and the employer, with its mixed statements, created its own conflict of material fact, which prevented the court from dismissing the case. And it went on, matriculated all the way to the Supreme Court on the summary judgment standard as to whether an employer can so muddy the water by telling different reasons, by lying, that it can't get a case dismissed. So it doesn't matter what it is, don't lie, because your credibility, you're held to a higher standard. Think about all the Bill Clinton stuff. The Republicans weren't so much interested in sex. They wanted to catch him in a lie. And so my advice to you is don't lie. You are going to have to terminate people. That's inevitable. That's the hardest part of your job. It's the one people shirk and delay. They avoid because nobody likes confrontation. But if you've done the first three steps and you identify a critical incident, you'll be a long way towards defending any claim. So I call that the straw that broke the camel's back. They were on final warning and then they did X. And if the employee admits they did X and their only grievance is, you shouldn't have fired me for doing that, the court will never listen to the employee. They will go, you admitted you stole an apple in the grocery store, and that's true. The employer had the right to decide that was a termination offense. But when this incident occurs, you should do an investigation that includes witnesses, that includes getting the employee's story. I think one of the worst things you can do is not tell the employee, it looks like you did X, and give them a chance to explain. And I don't want to be in a position where you're talking to the jury and the other side says, if they had only asked him his side of the story, you know, they would have found that his mother got run over by a train, if you get my reference. But always get the employee's story. Always have a witness when you counsel them about termination. You need to look back and how have we handled similar situations? And yeah, that's for consistency. But, you know, if you let 4 white guys go home because they came in smelling of alcohol and a person of color came in and you fired them, those numbers don't look good. So it looks like the reason was something other than coming in smelling of alcohol. So be consistent for legal and practical reasons. When in doubt, you can suspend pending the investigation. People go, is it with or without pay? Well, you don't have to tell the person when you suspend them. We'll figure that out depending on how the investigation shakes out. A lot of times just paying them for the time diffuses a situation. Sometimes if it's a workplace violence issue, you suspend them and then you call them on the telephone, which is not one of my preferred ways, by the way, and you tell them you don't need to come back because you've removed the threat of violence. So there are a lot of good things about a suspension. Another, by the way, is it gives an air of due process. And ideally, I think somebody in your organization should review every single termination because that's the point at which you are at greatest risk. And so if you have sort of an ombudsman, the director of HR, even the president looks at every termination, then you will more than likely be able to defend the ultimate termination. I had a client in Florida. He's a Florida regional director for a big distribution warehouse company. And the HR team would put together a sort of a dossier on people and say, these are the facts and we want to fire Bert. And this guy would always go, have you done everything you possibly could? And they'll go, well, I think so. And they go, I tell you what, I want you to think of one more thing before you fire this person because we value our employees. We don't like getting rid of them. And if you can do one more thing, then we're going to fire this person. And he's the only person ever to have that attitude, but I always admired him because he really didn't want to fire people. He wanted to give them every chance. And he challenged HR and the local managers to really go the extra mile to save and rehabilitate employees. There's always going to be high-risk terminations. Those are the ones you see it coming. The guy's been there 20 years and there's nothing in his file. He's been there a long time and nobody ever said anything. They let him get away with his mediocre performance. Those are going to be problems. If for no other reason than they expect that they get to stay there, nobody ever bothered to write me up or put me on notice. It's that feeling of ambush or surprise that runs people to lawyers. You know who those problems are. It's the person that complains about everything. They have an excuse. You know who they're going to be. If they're in any protected category, you need to stop and make sure that the statistics or the optics don't indicate discrimination. We have a right to look at the personnel file like it was discovery before we finally terminate someone, and you'd be well advised to do that. A lot of times timing is bad. Somebody comes in and says, I'm pregnant, and then 2 days later you fire them for poor performance. That doesn't look good. Or they complain about an OSHA matter. That doesn't look good. Not having a straw that broke the camel's back or a triggering event, that's going to be hard to explain. So if you think about it, the burden is on the plaintiff to put up what they call the prima facie case. Then it switched, and that is, I'm in a protected category and I got fired, period. Then the burden switches to the employer to explain, to articulate its legitimate, non-discriminatory reason. Once they articulate that legitimate reason, the ultimate burden then shifts back to the plaintiff to show that the employer's stated reason was a pretext. It wasn't true, and that there were other motives. Now, there's many ways that they prove pretext. A direct evidence, like if you hadn't complained about so-and-so, I wouldn't be firing you. That's direct evidence. Or we can't have pregnant people here. That's direct evidence. Rarely do plaintiffs get direct evidence. Most employers are smart enough not to say that. So, in virtually all these cases, the other side, the plaintiff, they're left using circumstantial or indirect evidence. They use timing. It occurred 3 weeks after I complained of harassment. So that's why timing is important. They use statistics. This is an all-white organization except for me, and I was the only black driver, and they fired me. They try to make those statistics look bad. Or 5 other people did the same thing, and 4 of them were not in my category. So that's why consistency matters. That's why timing matters. So just to refresh, it's all about being positive, creating an engaged culture. 4 easy steps. You get the right people, you set expectations, you coach them up, and then you get them off the bus, as one of those management consultants would say, and you're going to have to get 10% of the people off the bus. But if you do that, you'll have a culture of engaged employees. You think about when Saban was the coach at Alabama, everybody said, oh, he's a great coach. But he did 2 things kind of under the radar. Everybody knows he was a great recruiter, but all the other SEC coaches hated him because he washed out 20 or 25% of his players every year and got new people. So he understood that the 4th step is part of the performance management cycle. Again, I don't want to close on being negative. I want to be inspirational. I want you to have a holistic, constructive approach and to save employees. I also want to equip you with a way to explain to your management team why HR does all of these transactions and why we want them to write someone up and why we want to have a work rule. Because ultimately, it creates an environment where we can avoid litigation, keep employees safe, have the right culture, and ultimately, meet our business objectives. Does anybody have any questions? This has been a big monologue.
It's been a great monologue. I've been drinking out of a fire hydrant, a lot of refresher, a lot of reminder. One thing that just popped into my head, AI is in the news everywhere. Could you take a moment and I don't have a specific targeted AI question. So just in general, what would you say about how AI plays into any of this that you've shared with us?
Well, AI is a fantastic tool. I'll give you, yesterday, I have a lot of companies are going to a 980 work schedule where they work 9 days and then they take Friday off. And I had a client yesterday and they want to define, and that all depends on how you define the payroll work week. And typically you say the pay period ends at noon on Friday for everybody. And so therefore, you work 9 hours on Monday, Tuesday, Wednesday, Thursday. That's 36 plus 4 until noon and 4 after. In other words, you balance the work week. Now I say that because they wanted to set the work week based on an individual. And so I started looking at the regs and I said, I'm going to go to Claude, and I put in a query, and within 1 minute I had an answer with citations. I'm a lawyer. We have dozens of proprietary research tools. And I said, I'm going to experiment with Claude. And he gave me a brilliant answer. I went, wow. I sent, the question to one of my wage hour experts, and he said, I've never heard, I don't know. And I said, well, guess what? In the time I was trying to communicate with you, AI gave me this answer. I've had other clients, they send me policies. Now, I did have one client in the electrical contractor that was dividing its business, and they got this contract off AI. It was 15 pages long. It had IRS citations, and they were all wrong. They were hallucinated. So while it's really seductive, you do have to check it out. It is going to change the workforce, but not any more than, getting a tractor instead of having a mule, or having a computer instead of an abacus. It's a great tool that HR needs to manage. That's a long-winded answer, but
no,
that's fascinating.
Yes.
Other questions? So Bill and I were, I'm kind of excited about this because I think, from an employee's perspective, you want to be respected. You want to have advance notice. You want to know the rules. You want to be treated fairly and consistently. That's normal. We should expect that. We should deliver. And when you do, you get rewarded because, the American worker is an untapped resource. They know more about jobs than some of the managers managing them, and we need to engage them and leverage them and constantly improve. Well, so Bill, I got to put in a shameless plug if you don't mind.
Do it.
So a little personal background. I've done this for 40 plus years, and we write articles month to month, some of which I call Chicken Little articles. Donald Trump or Joe Biden is going to change the rules, blah, blah, blah. You've got to do X to drive people to action. Over my career, I've probably written 100 articles that I would call timeless. Do you need EPLI? Do you need an employee handbook? How do you conduct an investigation? And after COVID, I decided that I just needed to collect all those in a book. And so this book, Practical Tips for Human Resource Professionals, is a compilation of about 60 articles that I wrote over about at least a decade that I think are timeless. And they're broken down into different areas. But one of my career goals was to write a book. So this book is available on Amazon. I'm even more excited. I got 2 other books. One is at the final stage of the publisher, and it's on relationship building. But the third is using seminars like this, and I'm calling it Engaged for Success. And I'm really more excited. I've got 70,000 words on Engaged for Success, and I'm hoping that it'll be published by the end of the year. But it expands on most of the concepts we've talked about here. It's got a lot of other stuff. And one last anecdote, tying your question, Bill. It has like 32 chapters, and being the Georgia Tech guy, if you can't measure it, you can't improve it, right? So I didn't have anything on how do you measure employee engagement. So I used 3 or 4 different AI platforms and said, how do you measure employee engagement? So the chapter in my book that's under writing right now, 80% of it is a compilation of AI source materials. Because, I've told people how to have safe workplace and union free and harassment free, but I didn't have anything on the metrics of it. So I actually used AI for the 3rd chapter in that book. But anyway, I'm really just trying to get out all the information that I've learned over the years into these different books. And it's been kind of a passion project for the last year.
Well, Bert, again, before we sign off here, I would love to hear from those that are left on the webinar. You know, what we've talked about in the workforce group was maybe having a little mini series and start with this overview. But if in just a minute, anything regarding Bert's next, deep dive or going into a particular aspect of what he's covered, are there some topics that we might consider? And we don't have to answer it right now, but while it's fresh, I just enjoy to hear any thoughts on what might be a good next webinar along this theme of positive engagement, performance management. Any thoughts?
Bert, I've got a question for you, if you don't mind, instead of a potential other topic.
Sure.
I just joined Ernst in December, and I'm taking over our employee engagement survey that we have typically run twice a year. It is run through a third party called Culture Amp, and they have their own AI built into it to help generate questions, organize questions. You can add your own, etc. I've never asked an attorney this because I've never thought about it until you started talking today. Are there any liability concerns surrounding any engagement surveys?
Well, some of them, they've been violation of the ADA,
right?
But most of them are compliant. I mean, just look at the questions, and they can't have health questions on there.
Correct.
But I think that's a great way to do it. That's a great application of AI. And again, the surveys are great, but I've probably had half a dozen union drives in my career that followed an employee survey where the company did nothing. So they increase expectations. What kind of new benefits do you want? What other things do you want? Do you want parental paid leave? And then, yeah, that'd be great. And then they don't do anything, and they lose all their credibility because they didn't follow up on the survey. So follow through is absolutely critical.
Yes, sir. Thank you.
This is the draft cover for that book, if you can see that.
I see it.
For what it's worth. And I mean, literally, it's right here. But part of my, there's a whole chapter on upward communications.
Thank you, Bert. Appreciate it.
But anyway, this is fun stuff. I'm kind of a HR geek. People go, "You're a lawyer. Why do you write about HR?" Because that's my life. Because either you're going to do, I say we do two types of things at Fisher Phillips. We do train wrecks and transactions. The train wreck is the ICE raid. The OSHA guy shows up. It's an EEOC charge. It's a lawsuit. We can't control that. But you can do the right transactions that mitigate the risk and minimize the things you're going to do. And again, it doesn't do anything. I mean, we're friction. It doesn't add anything for me to win your race discrimination case. That is a complete waste of money for the company when it could be repurposed to taking care of employees.
And Bill, just as a recommendation, I sent this to Bert as well because I know he understands this, but I'm sure I'm not the only one who's SHRM certified on this call. It might not be a bad idea if we're going to do a bunch of these to consider getting a SHRM certification as an instructor through GRMCA, so that anything that we do offer for any of the folks that are involved, we can get some PDC credits for those.
Well, we have that certification. I could probably ask I'm not even sure who in our, I was the 36th lawyer. Now we have 800. We have a whole legion of overhead that takes care of that. So I have to figure out who's the right person, but I can check into that.
Well, it was just a thought, and then Berta actually already emailed that to you. So
That's
I'm
great.
going to propose that to Bill as well.
Thank you.
Yeah.
Thank you, Dan. Well, we've run out of time. And again, well, here's my phone. Sorry about that. We've run out of time, but we will do some thinking, and I'd ask you to think about what's next in this little series. So give it some thought. And thank you again, Bert, for taking your time and sharing this wonderful all these insights over a lot of years. I appreciate your friendship, and thanks to everybody who joined in, and we'll see you next time.
Okay. Thanks, Bill. Thanks, Emily. Everybody else.
See you guys.
Be safe.